from the President's own manifesto. I think there are 4 areas which I find particularly problematic and sort of like show some serious gaps in accountability. The first one is around the right to information. I think right from the outset we have to acknowledge the fact that the fundamental right to information which is brought to the 19th Amendment is not being repealed. So I think that's encouraging. I think the one thing is that with the changes to the Constitutional Council, to the Parliamentary Council, amongst other things, the actual operationalization of the right to information could well be impacted. And I think that's a very serious thing that, and I mean, we've seen how right to information has served so many people, ranging from someone trying to get their child into school all the way to getting information from Sri Lankan Airlines. That's something that we would not want to frustrate. Second point is on corruption investigations. One core thing which any anti-corruption agency should have is the ability to file actions on their own motion. You know, not waiting for a complaint to come, but to be proactive. The 20th Amendment is actually removing that power to be proactive. So I think that's also a key accountability gap. My other point is around public finance, and I can go into these in greater detail, but I mean, even looking at the issue around the Audit Service Commission, I think one thing that we don't always acknowledge is that there is now an opportunity for those within the public service who are guilty or rather who are responsible for misappropriation or willful negligence to be held accountable for those losses. By the removal of the Audit Service Commission, that ability to surcharge and hold people within the state sector accountable is being lost. And maybe a final point on free and fair elections. The 20th Amendment, and I think we can all acknowledge that during election time, the protection of public resources is essential. One thing particularly, and I think no one will disagree to this, is about the giving of jobs. The 20th Amendment stipulates that the Elections Commission very specifically should not be giving guidelines connected to the public service. Now, when it comes to, let's say, looking at the abuse of state resources, that's a big issue during election time, and prohibiting the Elections Commission from giving those guidelines is a concern. So I think, you know, for those 4 reasons, at least to start with, there are some problems if the 20th Amendment was passed in its present form.
Asoka, I want to drag your attention to a statement that was made by Professor Pratibha Mahanameheva. He said that some of the members of independent commissions have also gone to courts against the 20th Amendment to the Constitution, which will be considered tomorrow in the Supreme Court. Namely, an individual from the Elections Commission, that is Professor Hool, has gone to the Supreme Court seeking redress in terms of his capability of filing a motion in the Supreme Court. So, are these independent commissions really independent in the eyes of the public or even the international community for that matter?
So, I mean, I think on one side, there are things which are coming before the court, and I think we have to see how the court also deals with those things. But this point around independence, I think, is a important one, which is that, you know, independence is not a light switch that you flick on and flick off, you know. Independence comes from the friction of an entity like an independent commission holding government to account. That does not suddenly start and you know, it has to evolve, it has to be given the opportunity of taking root. I'm not, you know, I'm never going to say that independent commissions are perfect, the way in which they function, and I'm sure there are different ways in which they are problematic. I think part of the reason also is that sometimes the people who are put to independent commissions are sometimes, and I say this with the greatest of respect, but sometimes you find a bunch of 60-year-olds being put on these independent commissions, and they have never ever had to drive any sort of accountability and now they're suddenly being given the responsibility to be independent in driving accountability. I mean, I think it is sometimes problematic. There is sometimes a complete lack of zeal in actually driving the accountability mechanisms that they're in charge of. So those things are problematic, but that doesn't mean that you get rid of the entities, because the individuals who are even driving them may not at times be capable or approach it in the right spirit. You have to ensure that the right people are there to drive it forward. So this whole baby thrown out with the bathwater issue is a concerning one here, you know.
I want to very quickly, Ashoka, before I open the floor for questions from our journalists, very quickly, I want to drag your attention to the statement that was made by President Gotabaya Rajapaksa recently in the outskirts of Colombo. He says that whenever I make a statement, that becomes the circular. How do you view this statement now?
Yeah, I mean, I think, you know, it's a little tricky for a public servant to understand where authority flows from. Because, I mean, I think the statement may be clear, but I mean, there are also procedures within which public servants also have to function. So I think it is clearly a challenging situation that some public servants may find themselves in. But, you know, even tying back to that, to a point that we heard earlier, we hear the points around economic development. You know, economic development is also about attracting investment. Attracting investment is about being, I mean, in a country like ours, needs to be also anchored in the rule of law. So I mean, on the being anchored in the rule of law, and that statement that the president made, sometimes those two things do not align very closely.
Yeah, but the president very clearly says at this instance, I am the executive president of Sri Lanka and I make the decision. Is this a dangerous statement?
I mean, you know, the executive president is, needless to say, a very strong role even in its present form under the current constitutional arrangement. So, I mean, that doesn't mean that someone is above the law. You know, there still has to be accountability for the law, and it's also important that the president also continues to articulate the need for the rule of law to continue. You know, so I mean, I'm conscious of the fact that what was mentioned there, one would hope was mentioned in the heat of the moment, as opposed to a view of the general view of the president towards the rule of law.
Thank you very much, Ashoka Vesekar, Executive Director of Transparency International Sri Lanka. I open the floor for questions from our journalists. On to my immediate right is Nadir Majid. On to my left is Sharon Benedict, also a law student. On to my far left is John Fernando. Let's start off with John.
Thank you, Shamir. I'd like to stay on the same point, but right before I go on to the question, Professor Pratibha, I'm directing this question towards you. I would like to highlight certain comparisons between the 19th Amendment and the 20th Amendment. Yes, there might be certain parts of the 19th Amendment that has caused certain problematic situations in the country, but specifically focusing our attention towards certain points like the Audit Commission. We know, according to the 19th Amendment, it required the Constitutional Council to appoint a qualified auditor as an independent Auditor General, that is to conduct audits in certain government offices and certain institutions which fall under the government. But according to the 20th Amendment, now this empowers the President to appoint any person to this position to his sole discretion. The comparison between the 19th Amendment and the 20th Amendment. So clearly, while the 19th Amendment provided constitutional protection towards the Audit Commission, the 20th Amendment, well, it no longer requires, it takes away this protection, takes away the constitutional protection towards commissions like the Audit Commission. So my point is, while the 19th Amendment strengthens such commissions, which is responsible in conducting audits in order to make sure that no bribery or corruption is happening inside these institutions, the 20th Amendment is taking away these powers. To whose purpose, or who benefits out of all of this?
All right. Now, all these came with the gazetted draft. So the gazette, even there was a long time, so interested parties had a time to study this. I mean, this gazette can be changed. Where if you are talking about the audit commission, tomorrow the Supreme Court is, these petitions are heard. And then certain things can happen, because I am not going to give a preview. And number two, that is where I have to say, in the committee stages. So those are some of the, democratic process where these things are not a dictatorship. These are all used by political parties as a slogan from long time. Nepotism, dictatorship, likewise. Now if you see the democracy, hide into the democracy, if people are sleeping, will this country go up? That's why president has to intervene personally. And that is where last 4.5 years we have seen. If anything happened, constitutional rights. And I'll give another thing with the bribery commission. Now you say it's an independent bribery commission. All these last government ministers were called. How many times they visited? Example, Minister of Health former. No, they are not visiting. So is that independent? Is that independent? The bribery commission was calling certain ministers. They used this good government shield, hiding. So what is the use? You may tell, oh, this is a personal one, this is not a, constitutional. No, that's the practice we have. That's why we have to work hard. There are certain countries, I was in Jamaica next to Cuba, how they developed the country up to date, because they were actually going with the communist system, but people can say. Even there are other countries, Singapore, 1965 constitution. With that, Lee Kuan Yew got the power. For what? Not to abuse it, but to develop the country. That is my argument. And also this audit commission and auditor general, all these things, still there are certain provisions. So you can't come for a pre-concluded one.
How even sure are you, Professor, how sure are you that the present regime won't abuse power and they would develop it? How sure are you?
Yeah, people trust the president. Why people trust the president? That's why they give a huge majority. So the people having something in their heart, this is the last time to develop Sri Lanka. And also without going beyond with, certain other countries can put tackles. It is happening at the moment. But still, how he addressed the Human Rights Council.
But Professor, I believe for the past 70 years, the people have always trusted in who they voted for.
No, this
but
is
judging by the experiences of the past, can you actually be that certain that these loopholes or these protections that have been afforded, removing these protections would really, further the goals of the general public?
You are arguing from one side. I am arguing from one side.
Professor, I'd like to...
Wait. You are arguing from one side, I am arguing from one side. These three are arguing from your side, I am alone arguing on my own argument.
No, that's not correct. Professor,
wait.
No, that's not correct, because you know why?
Freedom of expression for me.
I will definitely give you, but
I am ready to fight. I am ready to fight.
No, I will give you the opportunity, but I don't think.
I need more time.
I will give you, because you are the only one who has been questioned so far in the second round. No, but the statement that you made about we being on one side and that is not right, because we are journalists and we have all the right. We have all the right to question you.
People will decide. The power is with the people. People had given a mandate. That mandate, president is executing. Even president innocently said whatever the statement he said should be the law. No, that is not the intention. Get the work done. So that's how we have to go forward.
The 18th Amendment to the Constitution.
Sorry?
18th Amendment to the Constitution was not an abuse of power.
No. I mean now.
No, because you said that the government has placed trust on this government.
Yeah.
Whoever was in the 18th Amendment Constitution government is also in the 20th Amendment to the Constitution government as well.
That so are you trying Parliament members or
Parliament members as well as the government also. 18th Amendment to the Constitution was not abuse of power?
I don't think so.
What was it then?
Because that's what I am going to explain. Parliament is the supreme democracy. So I mean, you are talking about the Constitutional Council, but I am supporting for the Parliament Council because they elect from the Parliament and also they are binding with them. When you are selecting these three civilians from the beginning,
You're not
I can
answering.
wait.
You're not answering the question. Yeah, I'm asking you.
I said the answer.
18th Amendment,
18th Amendment never
was not an abuse of
That's
power.
what I'm telling. That is my argument. So you can accept or you can reject it. Doesn't matter. But they did lot of things. I am telling how can these three civilians coming from one agenda, and one of the council member openly said, don't to support this support to a party. Is that independent? You may say no. People are there, not the system. You have not selected proper people.
But the pity is
that is your fault. That is your government fault. That's why if 19th Amendment really worked, I think they may not come up with the 20th Amendment. Why they came up with the 20th? Very simply, I'll tell. 1978 original Constitution. Whatever the powers given for the Prime Minister now basically
if
translates.
the 18th Amendment to the Constitution was not abuse of power, why did majority of the members who voted in favor of the 18th Amendment to the Constitution vote in favor of the 19th Amendment to the Constitution?
And these people once again,
Why?
I am not sure about that. I can't tell why they voted.
So let's
But once again they will vote for 20th
Yeah.
Amendment. Once again they will vote for 20th.
Unfortunately, that's how Sri Lankan politics is working right now, and it's very unfortunate.
No,
As
there is
due to
nothing
prospects of
unfortunate.
Sri Lanka,
That is your idea. But
no,
the people of the country, they know
it's quite unfortunate
what the process is
because
going on.
It's quite unfortunate. Anyway, moving on to Attorney at Law Lihini Fernando. Now, you have filed preliminary objections with regard to the 20th Amendment to the Constitution. A petition has been filed by you and it's going to be considered tomorrow. What were the key points that you all highlighted in the petition in question?
I'm not, because it's before the court and I'm not supposed to divulge the contents, but it is basically in general what we are discussing.
It's all in the papers.
It's all in the paper. So, so basically the same points of the 20th Amendment, the discrepancies that we have highlighted, the questions of immunity, all the factors we have brought it to the attention of the court. Basically, if I am to give you an overview, how it affects Article 3 and Article 4 of the Constitution, and that it should not be passed only by 2/3, but it should also be passed by a referendum. That's where the underlying, where it heads to. So we have challenged that the sovereignty of the people are affected, the rule of law is affected, checks and balances are affected, the fact of the discrepancies between the Parliamentary Council and the Constitutional Council, the dual citizenship matter, all that has been highlighted and brought to the attention of the court.
Where was the 19th Amendment to the Constitution when Arjuna Mahendran was appointed as the governor of the Central Bank, Sudarshana?
Well, to answer your question, Arjuna Mahendran was appointed during the 18th
100-day
Amendment.
program.
18th Amendment.
18th Amendment.
18th Amendment. 19th Amendment was actually brought in April. So this happened in January.
And the president on many occasions said that he wanted to remove Arjuna Mahendran from the post of governor, but he couldn't do so because he was an appointment made by then Prime Minister Ranil Wickremesinghe.
Well, I think our former president has made various statements and contradicted himself. He had the power to actually remove the Prime Minister. In 2018, October 26, he decided that he has the power to remove the Prime Minister of this country. So if that is the case, he could have removed because he made the appointment. So then I think you can't just go by this. Even the presidential commission appointed by the former president decided that appointment of Arjuna Mahendran was not a problem because that he had the necessary qualifications. The problem was what happened afterwards. So the appointment was not in a problem, but then subsequently I think he was removed. He was removed by the president. So I don't think that you can mix up the 19th Amendment and the Arjuna Mahendran together.
Sudarshana, this is a question that I had that cropped up recently surrounding the 20th Amendment and as Nini mentioned on presidential immunity. There are currently, if I'm not mistaken, 7 FR petitions that have been filed at the Supreme Court over the Easter Sunday attacks by families of victims of the Easter Sunday attacks. And in many of those petitions, the primary respondent is the president or then President Maithripala Sirisena. If the 20th Amendment is passed and presidential immunity from FR jurisdiction is introduced, does this mean that those petitions, that those families that are seeking justice and accountability, that they will not receive that justice or accountability?
Yes. This was possible.
But isn't it possible that it could be that the law could be not retrospective, but it's only for the current president and not for the former president?
Sorry, I couldn't follow.
I mean that when the amendment, if the 20th Amendment is passed, couldn't the argument be made that, at least in terms of these FR petitions over the Easter Sunday attacks, couldn't the argument be made that the 20th Amendment immunity is only intended for this president and future presidents and not the former?
True. No, that's true. I think there cannot be retrospective laws. So I think I misunderstood your question. My position is that it was possible for the victims, and including the bar association which I am a member of, to challenge the presidential action by way of filing a fundamental rights application, because that there was a provision to actually make the president questionable. You don't make president a respondent, but you make the attorney general respondent. So by way of that, actually you can bring. So with this new draft constitution, if that is going to be passed in its form, in future no one will be able to challenge the presidential action. So president will be will hold Ministry of Defence and any other ministerial portfolios. He cannot be questioned in the parliament because he is not a member of parliament. He is not responsible to the parliament, and in the same way he cannot be questioned legally in the Supreme Court because people will not have the right to challenge him.
So your opinion is that those petitions won't be able to progress?
Yeah, he will be placed above the law. So even the other case is that now under the 19th Amendment, President can only dissolve the Parliament at his will after the completion of 4.5 years. But last President decided to dissolve the Parliament, and people, the members of Parliament challenged the Supreme Court, made the the President's action was questioned. So the Supreme Court decided that President by dissolving the Parliament violated fundamental rights. Now the term, that limit is going to be brought down to 1 year. Now suppose even within 1 year President decided to dissolve the Parliament, what you can do? You can't just go to the court.
Lini, very quick question for you, given that I was initially going to pose this question to Sudarshana, but Sudarshana being a member of the UMP, the SJB being the main opposition party now, I'll pose this question to you. There is a lot going on in this country, especially with the 20th Amendment, with the economic hardships that the people are facing, and yet opposition MPs are wasting valuable minutes and hours in Parliament talking about the attire of their fellow MPs. I mean, is this really a national priority?
I don't quite agree with what you are saying because not that they are wasting the time of the Parliament. They have questioned the 20th Amendment. They brought in the argument about the standing orders when the Speaker arbitrarily brought that across. So not that they are wasting the time of the Parliament. So maybe some certain questions are subjective, which I don't want to make certain comments at this point. Probably it was taken up at that point, but I don't agree with you when you say that you waste the time of the Parliament, because the opposition has been quite vocal about the facts that have been brought by the government.
But when they're talking about the attire of the MPs at a time like this, a crucial juncture like this, it turned into a, maybe that was the intention, it turned into a music, because usually you'd expect that kind of distraction to come from whichever party is in power, but it looks like the opposition is perfectly capable of providing the distractions themselves.
My opinion is, I believe they thought it was a parliamentary procedure and parliamentary rules, so probably abiding by the parliamentary rules, they would have questioned that fact. So beyond that, I
But they
don't want to
went
make any
beyond
comments.
questioning the fact. They were protesting, they were undressing in some instances. I mean, you're in the house of the people, and this is how you've chosen to behave.
When you take a parliament, there are parliamentary principles, parliamentary procedures. Now, if I talk about the council which I represent, there are certain attires and guidelines which we need to follow when we go for the council. So it is expected to follow, and you know the decency and the decorum. Probably that was questioned. So that would have been the intention.
Asoka, very quick question for you as well. It's interesting that Transparency Sri Lanka is focusing on just these 4 issues in the 20th Amendment, when a multitude of other issues have been highlighted by not just the opposition but other civil society groups and even by other sort of actors and lobbyists and so on, including, for example, provisions around the urgent bills. Don't you see any corruption risks in those provisions?
No, indeed, and I mean maybe the urgent bills in particular I find problematic, but I feel that these 4 areas around right to information, corruption investigations, public finance, free and fair elections, those 4 things tie very, very closely with the mandate of what we work on. So I mean that's the reason why I sort of flagged them up. I think there are other very significant challenges as well, but I mean I've just sort of kept my focus on these 4 points in light of the fact of the mandate of an organization like ours.
What's the process now in terms of amendment? Because Lini was talking about parliamentary rules and procedures. There is a parliamentary procedure which is often overlooked by, well, it was overlooked previously by the UMP-led government, and if significant amendments are made to the 20th Amendment, then in committee stage, then it will be overlooked by the current government as well, which is one of the standing orders, which says that you cannot make any changes to a bill which would change the nature of that bill.
Yeah.
So, if it comes to a point where amendments are being introduced at the committee stage, I mean, this was also overlooked with the 19th Amendment. If this comes to committee stage amendments, will you advocate for those amendments to be included, even though it's a violation of Parliament's standing orders?
Well, I mean, I think what you're touching on is actually a enormous gaping hole in our parliamentary practice, which is the fact that the whole, especially when, and you see it particularly when it comes to a constitutional bill, when you have a need a two-thirds majority to pass it, but then the horse trading around the committee stage amendments can pass with a simple majority. So I mean, it is a challenge. I think that, I mean, I can't even begin to speculate as to what those final committee stage amendments would look like. I think we have seen in the past times when, in very bad faith, like some bills are almost brought hollow, and then a lot of the content comes in there. But I've got a feeling if there are committee stage amendments to the 20th Amendment bill, I mean, you know, it would most probably be in keeping with the provisions that are already there. So I mean, it's very difficult for me to speculate on what would happen at the committee stage.
Yes,
regarding the sectoral oversight committees, now that was something significant that was brought by the 19th Amendment, where the government and sort of the civil society, how they can integrate towards the governance process. For example, if I may bring up this whole concept of women, the Domestic Violence Act and all that, these were taken up, these bills were, Domestic Violence Act of 2005 number 34 was in the revision stage, because the practicality, the implementation of that act had issues. So the Sectoral Oversight Committee, which debated this, with the participation of many civil society organizations, it was debated continuously, and they were revising this bill. So that was a significant step that was brought in by the 19th Amendment, which I think which was brought in the Parliament recently, and which the opposition objected.
Was the amended bill passed?
It was, if I'm mistaken, it was brought in, and the speaker brought in, and then SJB opposed the abolition. So
Lina, I have a very quick question for you from a viewer. Dr. Mahanameheva said that people trust the president 100%, and that is why he was given an overwhelming majority in Parliament. How dangerous would it be if these powers go to the wrong hands? This has always been the case in Sri Lanka. Every government comes in, changes the rules, suit themselves, and has always had a detrimental effect on our country and its people.
Exactly. I did want to interrupt here. I'd like to raise this question. Are constitutions designed to facilitate certain leaders, or is it designed to enhance the system? So here again, the 20th Amendment is brought and centered around this particular president who is in power right now. What if his president is no more and if a different person is brought in? Will that person abuse the power? So from what I understand, from what I know, the legality which I have studied, constitution should be drafted based on constitutional principles. If by any chance, if one organ overrides the other organ, then it is not a good constitution. So with the 20th Amendment, that is what they are trying to do. Give this enormous power to one particular figure called the president, make the parliament, make the speaker, make the PM defunct, I would say, to a larger extent. If the president, now you take the parliament, is been elected with the mandate of the people after the general election, and if the president has the power to dissolve this parliament after a period of 1 year, what does it say about the franchise that is exercised by the people? It's questionable.
Dr. Mahanameheva, what is your response to that?
20th Amendment, only a interim one. Once again, I am going to reiterate that. You said, Professor G.L. Piri said, within 6 months they are preparing a draft. So we can wait and see how this new constitution is coming up. And it is going for a referendum also. Definitely. Even I think after hearing this petition, Supreme Court can give a verdict. Certain sections you have to go for a referendum. That I am not going to pre-focus that.
But certain sections of the Sri Lanka Pojana Peramuna itself, and even in the cabinet, opposed the 20th Amendment draft bill in its present form, Professor Mahanameheva.
Yeah, there can be other parties also. I think the Prime Minister also appointed a committee to see all these things. Thereafter they said they will consider this in the committee stage. But the question you asked, 20th Amendment is not the final conclusive for the next 5 years. Until a new constitution draft. So we have to select one, whether we go with the executive presidency system like 1978 or we go for the parliamentary system.
So why in a hurry why in such a hurry does the government want to bring in the dual citizenship clause if it's an interim report?
Now, my argument, dual citizens can vote in this country.
No, this is interim.
That's what I'm telling.
No, that's what I'm asking you as well.
My position, even still this is a draft stage. I don't know what will happen with the other parties' consensus in the committee stages or in the Supreme Court hearing. I mean, there are plus and minus. So,
even you believe that the 20th Amendment in its present form is not right?
No, I think if, this is my argument, if a citizen with a dual citizen, if he can vote, he can be a member of the parliament. But I have my reservations, a dual citizen contesting for the presidency. So, likewise, I also have some reservation. But at the moment, what they want to do...
So, even you agree that the 20th Amendment is not right in the present form?
That's why I am telling, 20th Amendment is only a relief. Once you establish a new government, new constitution.
But Dr. Mahanameheva, relief from what?
Relief because president need to run the country without restrictions, limitation with the so-called Constitution Council.
But what are the restrictions? We've seen how he's handled the government led by the president with the support of the Triforces, the health authorities, the doctors, the nurses, the attendants, so on and so forth, with the entire
more things are there.
They have been able to handle things very well. What is the specific constitutional obstacle to development?
Constitutional Council.
How is the Constitutional Council an obstacle to development?
Certain appointments we have seen in the last government, but still the Constitution Council is existing. With that, you can restrict the president power. So the president is basically with the non-political and a former government servant. So he has his intention to go smoothly this country. This is my argument. It can be your argument also.
No, I'm not making an argument. I'm trying to understand.
Both sides' arguments are there.
No, Dr. Maname, I'm trying to understand your argument.
7 into 1.
Dr. Maname, I'm trying to understand your
No,
argument.
that's
I don't have an
again,
argument.
I
don't have an argument. I'm trying to just one question, just one very quick question.
I'll give you an
One very quick question.
I'll give you an opportunity to speak. But Professor, it's all right for you to say that 7 against 1. There's definitely 3 individuals who are opposing this particular petition in question, or the 20th Amendment draft bill in question, and that is Ashok Obesekar, Lihini Fernando, as well as Sudarshana Gunawardena. John, Shalan, Nadeem and I, we are asking questions to get some clarity from the government's perspective as to why they brought in the 20th Amendment to the Constitution, but that doesn't necessarily mean that we are not posing difficult questions to Sudarshana, Lihini, as well as Ashoka.
I am not a
No, because you tend to
come and support this situation. I have seen many countries how they have developed with that structure. I like this present government how they work, so that's why I am putting my arguments. Okay.
So, Dr. Maname,
support the government initiatives rather than heading this country to difficult situation.
Fair enough.
So that's why I said 20th Amendment is a interim one, as well as we can't put patches. So better immediately they may come up with a new constitution and go to the public and get the mandate. Opposition can't do anything. They are also dividing. Opposition members are ready to support for this government. Likewise,
Dr.
Maname, things are coming up.
Understood. Now you say that the president needs these powers in order for there to be development. Now let's take recently statement issued, or rather letter from the secretary to the president came to light, that they're going to scrap the light rail project, which is to be funded by JICA. Now this was a major sort of overhaul of public transportation project initiated under the previous government. Maybe that's why it's being cancelled now, but there was no constitutional obstacle to cancelling that project and going for something else. There's no constitutional obstacle to building a highway. There's no constitutional obstacle to the president and the prime minister working on the budget right now. Don't you think that right now, given the economic condition that the country is in, that the budget should be a bigger priority than a constitutional amendment?
So budget also coming up immediately after that's why I read the news. First they go for the constitution clearance and then they come up with the budget. So there are prioritizations. I don't know. The government must decide whether the constitution is the major priority or the cost of living as well as other things. But they all do meet and there are committees which they decide. So at the moment, you should give power to the president to run efficiently and to remove obstacles. You said there are no obstacles. President can do anything because certain projects are there, highly corrupted projects also there. But the issue here, my main argument, Constitution Council. That's why I am saying the president cannot appoint certain positions because Constitutional Council can obstruct, and if you go with the 19th Amendment, even presidents were not there. The names were within 14 days come into effect. That's how the former IGP and different posts were there, and even in the bribery commission. So my argument based on that, clear it and go for a new constitution.
So Sudarshana, if that's the case, as Professor Mahanameva points out, the Constitutional Council is the biggest hindrance for development in the country at present. Why not just include this particular clause in the 20th Amendment of the Constitution and forget about the rest of it?
No, that's my point. That's why I'm saying that proponents of the 20th Amendment actually argue on they are all over the place, and sometimes they actually contradict on each other.
No, because one clause in this 20th Amendment to the Constitution that is being gazetted is bringing down the age limit of a president who could contest an election has been brought down from 35 to 30. The point there, I still don't understand why. Do you fathom why?
Me neither. I also can't understand, because how this bringing age limit down serves any of the purposes that actually we hear. But going back to this Constitutional Council, the idea of Constitutional Council is to create a situation where Parliament take control over making appointments to the important public officers. And also that should be not that the government or the government party making these appointments, but trying to come to a consensus approach.
But Sudarshana, on that same notice, I mean, Dr. Manavana makes an interesting point there. You have three, as he says, civilians
Yes. No.
who are not elected by the people. I mean, shouldn't this be something that's handled by a high post committee in like an institution like the high post committee in Parliament?
See, I mean, there can be different arrangements. If you oppose these three civil society people, because in the 17th Amendment, it was 7 civil society members. But here, there are only 3. And even these 3 members, they have to be actually get the approval of the Parliament. Parliament in majority must approve this appointment. So you can't simply get someone and place there. So my point is that there was a model that we thought that getting the government and opposition and also smaller parties together and getting civil society in will create more conducive situation where you can have a more independent institutions, and also you can create the key positions like the IGP and the Attorney General more independent, because we have to understand that we are a country went through a conflict and various groups actually fought against the state, saying that state is not democratic enough. So there was a huge democratization drive, and everybody agreed that there was a democracy deficit even after the 18th Amendment was introduced. So therefore, one form of experiment was done by way of getting this constitutional council. So if the constitutional council is the problem, then that can be taken separately and addressed. So my question is that given the present setup, the constitutional council can be reconstituted to suit the new government policies. So it doesn't mean that the same people will continue.
So, Professor, a response from you with regard to that. If the Constitutional Council is the problem, why not only incorporate the Constitutional Council amendment to the 20th Amendment of the Constitution and not talk about bringing down the age limit of a president who will be contesting from 35 to 30, abolish the Procurement Commission as well as the Audit Commissions with regard to looking at the president's offices and so on and so forth. Why bring the dual citizenship into play? Why all this?
Can I just add 2 things for the
Yes.
Constitutional Council, Parliamentary Council? Now, the 20th Amendment, the 5 members that have been proposed, Speaker, Prime Minister, Opposition Leader's representative, PM's representative. The 2 representatives can also be removed by the President. Now, that is a danger. So then it affects the equilibrium. So then the President, the Parliamentary Council can be completely biased, because the President has the option of removing those 2 and appointing 2 people.
Okay, for that I will respond. Now see, when the good government was set up, who was the opposition leader? Who was the Prime Minister? Prime Minister and opposition leader having same type of opinion. That's how they go to Geneva. Suppose there are independents there, Mr. Sambandhan as well as Mr. Ranil Wickremesinghe, and how they appointed the other party members with the consensus of Prime Minister and the opposition leader. So opposition leader is not objecting anything, big house, big cars and other things were given for him.
No, but they say the same thing.
Wait. After that you can respond. I need more time, right?
Okay.
3 to 1, right? Okay. So what is happening here? More and more discussions were there. Their people could be appointed, right? So this is where the dangerous things happening. And I don't know how the civil society, more people were there. What is the selection criteria? When you are selecting the civil society, they appointed very biased people for that government. Was there any criteria? Was applications were called and asked from the general public, we are going to appoint X or Y, and he said nothing.
You mean to the Constitutional
Nominee.
Council or to the commissions?
I am
There was
asking.
Dr. Adhika Kumara.
All. No. I'll respond for that. Constitutional Council first.
Yes.
Tell me, when the Constitution Council, you know the truth, when the civilians were appointed,
Yes.
how they were appointed? There were no proper criteria, no interviews. General public had no time. So,
Not general.
Sudarshana, my good friend, you have to see it. See
No,
the people who were appointed. This Constitutional Council is only a, rubber stamp of Prime Minister. That's why
No,
I'm telling
no.
you.
No,
Rubber
I
stamp
think-
of
I
Prime
think that-
Minister. That's my argument.
Yeah.
Now they're
That's why
officially
I'm
making
saying-
it a rubber stamp through the
It
constitution.
will come one by one. Will come.
So then, yeah. So my good friend says that the former Constitutional Council was a rubber stamp, but still that rubber stamp had the power to actually make appointments to the independent commissions, and President had to appoint these appointments, and also vet the appointments to the higher posts. But
Even
now,
President
by
doesn't know what to decide
criticizing this,
I am not
May I
criticizing.
read
I am
articles?
criticizing the Constitutional Council.
Methodology.
No, no.
May I read Article
By-
41A of the
no, by-
Constitution,
by
please?
criticizing the Constitutional Council, now the 20th Amendment is created a Parliamentary Council, which is a rubber stamp. So that's the problem. If the
It's a
Constitutional
rubber
Council is
stamp,
a-
even with the Parliament. Some unknown people are becoming a rubber stamp. It is worse
No,
because these are the members of the Parliament.
the-
The
you-
three
that's
people.
Sorry.
Professor-
Constitution Council.
Professor,
Constitutional Council.
Professor Mahanami, you spoke about Sambandhan and Ranil Wickremesinghe being on the same side.
Yes.
Am I right?
Yeah.
Wasn't that the same case when President Mahinda Rajapaksa was the
No,
president
first-
and Ranil Wickremesinghe was
First
the
we'll
opposition
go with
leader?
the Constitution Council.
No, wasn't that the
then
but
we come to
this
the
is what you said.
Parliamentary Council.
No, this is what you said. You said that R. Sambandhan and Prime Minister Ranil
Yeah,
Wickremesinghe
yeah.
were on the same side.
Yeah.
Wasn't it when President Mahinda Rajapaksa was the president and Ranil Wickremesinghe was the Prime Minister? Was it the same situation?
That is later situation you are talking
Opposition
about.
leader.
But see the present situation, and you are talking about the Parliament. Parliament, the earlier it was a very minimal side of the government, but they took, I don't know how they changed the Prime Minister and all. That is a different question. But I am going to tell you one thing. These Constitution Council members made certain statements in Geneva and other countries. Mr. Sudarshan was mentioning that because this is where it goes. So it's reflected how the country was working. So my argument is this: no need civilians. Okay, let's come to the Parliament and work it out. If there are certain loopholes, yes, I agree. As Miri perfectly mentioned,
Shamil.
yes, cannot be removed. Then you can consider how this Parliamentary Council should be set up. I agree with that. I am not telling everything, but there are certain things. No, you ask other things. Audit Commission, Procurement Commission. Yes. Now, Audit Commission, basically, auditing is needed for any institution. I am not telling that, but we have to see how we can reinstitute this. This is the argument. This is the debate we need in the country today. So, my argument is even a private company or even a public institution, you have to be audited. So
No, because
that's why the auditing-
in that event, like the
I
Silvedi
agree with
case,
that. I agree
the
with
Silvedi case that took
Yeah.
place
Yeah, I am
can
not-
happen again.
I am not telling, so that's why they may go in the committee stages one by one. Even SLFP has appointed a committee. I saw it today. So,
But
when
Dr.
they go in-
Manoeva, as I mentioned to Asoka before, if you make significant changes to a bill in the committee stage that change the nature of the bill, that is a violation of the standing orders of Parliament. You can't do that. So the right method is for the bill to be withdrawn. Since the governing coalition, the SLFP, SLPP, since the partners of the governing coalition seem to have or appear to have some indecisiveness on what they think should be the nature of the bill, isn't the right procedure to withdraw it, discuss it, finalize the issues and then regazette it?
No.
As was articulated again by Professor G.L. Piris in Parliament when the 19th Amendment was presented for the first time.
Yeah, that's why I'm telling. If there are certain loopholes, now the opportunity is there with 39 petitions are there. So in the Supreme Court, determination, this has to go for a referendum. Yes. And I saw the Minister of Justice saying, yeah, they are ready for a referendum. So nothing to, I mean the opportunity is still there. Opportunity, wait. Opportunity is still there. Keeping the opportunity, you all say, no, this has to be amended. So the Supreme, wait, give me time. 3 into 1, right? So the Constitution, basically, the draft one came up, and it has gone to the Supreme Court. So government will abide by the Supreme Court decision. So you can come for a pre-assumption these things are there. All right. And then if even certain, I know what happened in the 19th Amendment. They were trying to take the full power. See the Honorable Justice Sri Lanka judgment. Certain things you need for a referendum. So what Mr. Ranil Wickremesinghe government did, slightly dropped that and got certain things. What the 20th Amendment, once again transferring for the original system or the original 1974.
Yeah, sorry.
May I be permitted to
Sudarshan,
correct what he said on the Constitutional Council?
Yes,
Professor mentioned that, may I read Article 41A, subsection 1E of the Constitution regarding these three distinguished persons that are appointed. These nominations made by the Prime Minister and the Leader of Opposition are required to be approved by Parliament. In nominating the 5 persons in terms of Article 41A, 1 subsection E, the Prime Minister and the Leader of the Opposition shall consult the leaders of the political parties and independent groups represented in Parliament so as to ensure that Constitutional Council reflects the pluralistic character of Sri Lankan society, including professional and social diversity. So that was the objective.
That is the theory. In practice, it never worked. The practice is former Prime Minister Ranil Wickremesinghe, what he said, everyone was silent.
Leanie,
May I ask you
I'm going to
please check it.
I'm going to actually put this question on. It may sound like I'm arguing on behalf of Dr. Manu, but I'm really not. I mean,
no, please argue.
At the end of the day, in 2015,
Yes.
Following the parliamentary election in August, it seemed that the President, the Prime Minister, and the Speaker, those political realities. The political reality is that the person who led a 16-member group of Parliament was given the position of opposition leader. A person who led a 6-member group of Parliament was given the position of chief opposition whip. And the largest group in Parliament, numbering I think 56 joint opposition MPs at the time, were deprived of recognition as the largest group in opposition. I mean, that really blew up in the Yahapalna government's face, didn't it?
See, again, coming to the 19th Amendment, yes, there were, and I'm not saying that the 19th Amendment today is, from what you said also, it is not perfect to an extent, but what should happen right now is to amend the 19th Amendment and go forward, not to bring the 20th Amendment. Yes, what your question, I agree, there were constitutional violations, but it happened because there was the President that was appointed and the Prime Minister, there was a Yahapalna government that was brought back. Yes, if there was a constitutional violation, then the opposition could have gone to court. But that when the PM was appointed, when he didn't have the majority to be the Prime Minister, they could have gone to court. But they never went to court. They accepted the fact.
I'm saying in August 2015, after the parliamentary election, when we clearly had 2 factions that were running against each other. The President, despite being the leader of the UPFA, the prime ministerial candidate of the UPFA at the 2015 August the August general election was former President Mahinda Rajapaksa.
Yes.
He was defeated, but the alliance won, I think, 86 seats, something of the sort, the UPFA.
96 seats.
96 seats the UPFA won. Then, since a few of them were loyalists of President Maithripala Sirisena, they opted to remain with the government. But the largest bloc group of opposition MPs was still under former President Mahinda Rajapaksa. And this bloc group of MPs wrote to the Speaker, wrote to the President, and they nominated then MP Dinesh Gunawardena to be the opposition leader. That was the position that they took. This is the largest opposition group of MPs. But it appears that the then President and Prime Minister, who were still on good terms and hadn't broken up yet, they hadn't gone through their messy divorce yet, and the Speaker conspired to deprive the opposition of a voice. And 2 smaller parties in opposition were given control of the opposition. Isn't that the truth? And isn't that what has now come to bite Yahapalna in the back?
Can I?
Yes.
I mean, yeah. Because I think in retrospect, I also think that it would have been better if Mr. Mahinda Rajapaksa led opposition was given the position of leader of opposition to lead the opposition. That would have been much better situation. But there was a technicality at that point, because for some reason Mr. Mahinda Rajapaksa decided to contest under his former foe, President Maithripala Sirisena's leadership. So Maithripala Sirisena was the leader of that UPFA coalition. So he, as a leader of UPFA and as a leader of SLFP, decided that SLFP should join the government, and he was the president. So his party joined the government. While I agree that it would have been better choice that Mahinda Rajapaksa should have given the position of leader of opposition, then you have a situation where one party is in the government at the same time in the opposition. So that's a technical issue. So you have to understand that now.
But Sudarshan, it's a technical issue. The technical legal issue is understood because the leader of the party was the one who had to communicate the decision, and the decision was made. But it was still an injustice by the public mandate.
Yes.
This is what the public wanted as the opposition, but the others acted in violation of it. And don't you feel that it is this lack of genuineness on the part of Yapalnya that has now put the 19th Amendment at risk?
Oh, I think we cannot defend everything, and it's a time you have to retrospectively look at the past and see.
But the thing with technicalities is this: it is also a technicality that Parliament standing orders must be obeyed, and you can't violate standing orders.
Yes.
But see, you're talking about technicalities, but the Yapalnya government had no problem ignoring those standing orders when they passed the Provincial Council Elections Amendment Act, when they passed the 19th Amendment.
I think you are arguing on a very idealistic position. 19th Amendment and the Yapalnya government was brought in order to address the situation created by the 18th Amendment, where the country was taken into a constitutional dictatorship, because the president could contest again and again for many times. So therefore everybody got together to make a change, and then they managed to get a opposition candidate as a president. So then there were certain changes were done, and these changes helped the country to overcome this democracy deficit. So again, in retrospect, you see various flaws. So it's time to correct it, and this new government got a mandate to correct it. That's why they got elected. The question is that without correcting the wrong done by the Yapalnya government, actually now they are trying to revert back to 18th Amendment. So that's the question.
I disagree with that. If you give time after his argument, I will explain the position.
A quick question for Asoka, if you don't mind. Asoka, you mentioned earlier around how you need to be anchored in the rule of law if you want to attract bona fide foreign investment. Now, I posed this question to Dr. Mahanamahewa earlier, and he articulated that one of the main obstacles to the president executing this thing is the Constitutional Council. Do you see any constitutional obstacles to the execution of the president's manifesto?
Constitutional, sorry, could you repeat?
Obstacles. Do you see any obstacles in the current constitution, in its current constitutional framework, within the current constitutional framework? Are there any obstacles to the president delivering on the development agenda?
Well, I mean, looking at the areas which, you know, where I touched on earlier as well, I mean, it doesn't seem like there is an enormous impediment for him to take things forward. I think there's progress that has already been potentially made. Obviously, the economic conditions brought by the COVID crisis and things have made the situation quite difficult. That doesn't mean that removing oversight on public finance, things like that, will solve the problem. I think one particular point which may have been touched on briefly before was even around the fact that removing state-owned enterprises and entities which are state controlled which are registered under the Companies Act, removing that from the oversight of the Auditor General. The idea that therefore Parliament can no longer be reported to on the financial position of those state entities, I think those things are, you know, I don't think there is a economic advantage from ensuring that there is less oversight by Parliament.
Also, I think it's fair to say that sometimes in governance, decisions need to be made swiftly. And maybe an argument could be made for the case that sometimes, maybe in an extraordinary situation like dealing with a global pandemic and having to, you know, shut down airports and having to make certain ad hoc arbitrary decisions, that you need to bend the rules, let's say, somewhat. Do you think that there is a rigidity in our current constitutional and legal framework that prevents that kind of responsive action?
You see, the thing is, you know, I think my point of view is to sort of depersonalize this from the characteristics of any individual. This is about the constitutional arrangement that could be in this country for a very, very long time to come.
Exactly.
So, I mean, that is, you know, the concerns of the present right now are very different to the concerns of what could be the case in 15 or 20 years' time, when it's a completely different set of characters. So, I mean, the constitutional arrangements now, this idea of tinkering with the constitution, saying, oh no, but there's going to be a new one later on. The idea of doing that in a collected fashion right now, when I also feel that the president is also in a very strong position in light of his majority in Parliament as well for the Porto, it makes sense to take a little bit more time and then deliver that final constitution right now, because these steps right now could well be setting a trajectory for many, many, many years to come. So, I mean, that's where my sort of slight concern comes, because, you know, time bends in very different ways. 6 months for a new constitution could actually be 20 years without another constitutional amendment. So, I mean, we need to ensure that what we get right now is fit for purpose, not for the next 6 months, but is fit for purpose for the future. And I think the president, in fairness, is someone who is also, in his mandate, is also trying to think about the future, think about things a little differently, but then trying to go back to the old constitutional arrangement, I feel is a little bit too much of the past and not much of the future.
So on this question of constitution making not being for the interim, I mean, that was the same argument that was made when the 19th Amendment was brought in, and when some groups in the opposition, specifically in the joint opposition, raised concerns regarding the 19th Amendment. The argument that was made was, oh, this is a transitionary amendment, we're going to be bringing in a new constitution.
Yeah.
That never materialized either. But at that point, a broad cross-section of civil society supported the 19th Amendment. It seems that, is there a double standard?
No, I mean, I think even with the 19th Amendment, let's say reintroducing presidential term limits, the right to information, things like that, it's encouraging to see that those are not being rolled back through the 20th Amendment.
Yeah.
But I mean, even in giving surcharge powers, all of these developments I think are good. I mean, all I'm saying is that if there is if there are issues with the 19th Amendment, and there are many, and I mean, ultimately the 19th Amendment, even the original bill, and what finally came out after the committee stage, because I mean, you know, it was a very, very different bill after the committee stage. Lots of committee stage amendments made. I mean, very, very, I mean, it certainly is not perfect, but it took certain steps forward. And I feel that when it comes to delivering the economic future of the country, no one has made a very, very clear argument, pulling out a few key points as to how the economic situation enormously improves itself through the 20th Amendment in its present shape.
Yeah.
So I mean, this is not about opposing it for the sake of opposing it, right? I mean, I have no political affiliation at all in this matter. It's just that on these 4 key points which I have articulated earlier, I mean, there needs to be some sort of public explanation as to why that needs to happen.
Can you do a small favor and tell that to Dr. Pratibha Mahanameheva
On one side, someone says, why are you going, a couple of years ago, people are saying, you're the one trying to, pushing for the Prime Minister's asset declaration to be made public, right? And then you get cast in one camp. Then on the other side, when you're just trying to make an argument about basic constitutional norms, then you get shifted to the other camp. So I mean, I'll get shoved from one camp to the other based on which political agenda that the other individual has. I mean, that's par for the course anyway for in my job.
Yeah. Shraddha?
I have to respond. No?
Actually, Professor, my question is to you, and an opportunity for you to respond. Now, we've seen throughout this debate, you highlighted on a number of occasions that it's 3 against 1, and so on and so forth. And judging by the arguments that were put forward by the other speakers, besides yourself, they accused this amendment to the Constitution as being an autocratic one. One that reduces transparency, one that reduces accountability, one that hinders the process of checks and balances, and in the end leads to an autocratic system of government. And of course, that is clearly not what the people want, because if that was what the people want, the government should have run on the promise saying, we're going to create an autocratic government, we're going to have Hitler as a president or whatever position. So that's not what the people wanted. My question to you, Dr. Professor, is what are the salient features in the 20th Amendment? What are the salient features in the 20th Amendment that you see that are not autocratic and that promote actually accountability, transparency, and democracy as a whole, which is what this government really promised us?
Certain words you are using, I don't think it may be suitable for the
I was just reiterating the words that were used
You have
already.
the freedom of information, you can say Hitler or Gaddafi or anything you can say. But I know when you are representing certain things from where these roots are coming, right, doesn't matter. So you have the freedom to use any leader's name, but I think this is not autocratic. Once again, I am going to tell you, as Sudarshanas, my friend, learned friend, perfectly said, 19th Amendments, there are loopholes. Why can't you correct the loopholes and run the system? That's why their main argument, right? So the 19th Amendment, I don't know, the supporters, why they make these loopholes, right? That is question number 1. And certain people using the 19th Amendment easily getting the citizenship in other countries. For certain things I can say people use this 19th Amendment to get certain benefit, but democracy is there, no problem. So they are showing to the whole world, even the West, hey, look here, we are having this type of problem because we made the 19th Amendment. So this is another side of argument I am telling. But if it is autocratic or not, people will decide. The president gave a promise definitely to scrap or abolish this system. What is the system? This is 19th Amendment. So they may have thought, I think they may have thought, rather than going with the 19th Amendment, the promise said given to scrap, we will go for a new fresh constitution. For that, definitely there can be a referendum, 2/3 majority of the government. But you are asking why so hurry? Certain things we have to do it. Because last 4.5 years dragging and no development.
Professor, if I may qualify my question a little bit more, Attorney at Law Lihini pointed out that the provision to give blanket immunity to the president is setting the president above the law, and therefore it can be cited as an autocratic provision in this clause. Then they also cited the fact that the president being given the power to appoint judges to the superior courts, the Judicial Services Commission, the Attorney General, the Inspector General of Police, and other key positions is also, including the Secretary General of Parliament, also infringes on the separation of powers and therefore is bad for the separation of powers and thus is an autocratic provision in the 20th Amendment. My question to you is, what are the clauses in the 20th Amendment that actually promote transparency, that promote democracy, that promote accountability, which is at the end of the day part and parcel of what we want?
My argument is this: there is nothing autocratic. This 19th Amendment, once you abolish, it will come to the original 1978 Constitution. So the 1978 Constitution, which is where autocratic or whatever the rule, I am telling you, because not a new. Now let's see if with the amendments, if they have introduced something ultra virus, going beyond the power, still the Supreme Court, determination will be given. So nothing to worry about that. You always see, right, this is autocratic one, this is executive president.
I'm not saying it.
If people like, we have to obey that. 405, certain groups or NGOs or foreign funded, or you can, because their agenda
Yes,
is based. Wait. Their agenda I have seen in 2014 in the Geneva. Mahinda is not listening. Therefore, this regime should be changed. That's how the slogans are coming. Nothing to hide. Sudarshan knows all these things, right? But I am going to tell these things are where foreign funded government or foreign funded constitution we don't need. So we can come up with one constitution. Until that only I have seen this 20th amendment. 20th amendment once again empowers the president to run the system efficiently. Once it has been established, like in Vietnam, like in Singapore, like in many other countries, like in Cuba, Venezuela finally it collapsed. So the system we have to prepare. For that we need some culture, we need some training. For that training only up to certain level.
Professor Mahanama, in your opinion, who drafted the 20th Amendment to the Constitution?
My argument, drafting is not a material for me. I am looking the contents. So these are some simple questions you are asking me. Who are the drafters? Who are the authors? You can ask these things. Doesn't matter. Let me think the content first. Let me think the content. But finally, President said no. Me and the cabinet. If this question came up. The other thing I just want to tell you, when a constitution is drafted like an amendment, you can't be so hurried. That I agree. Even India, it took 4 years. Many countries. So the people participation is needed. I know last government also, wasted big amount. Last 4.5 years, they visited a lot of areas and they have also drafted a constitution. But finally what happened? They didn't come up with that. So they want to embark with 19th amendment and to control the president and to run the system. That's how it works.
You wanted to say?
Professor said that with the 20th Amendment, you're going back to 1978. I'd like to ask the question, when President Chandrika Bandaranaike came to power, when Mahinda Rajapaksa contested, didn't all of them say that they want to abolish the 1978 constitution? Wasn't that an election promise that was given? Then from the 19th Amendment, we achieved significant progress in this country where there was accountability between the President and the Prime Minister. The President was a person who's responsible to the Parliament. That was a significant achievement in this democratic framework in this country. So now what we need to compare is what we have achieved from the 19th Amendment and going forward. If there are flaws in the 19th Amendment, let's correct it and go forward, not go back to the 1978, which they themselves came in the election stage and said that they need to abolish.
Shamir, if I could ask one more question from Ashoka. Ashoka, now let's give the government the benefit of the doubt because we don't have direct government representatives on our panel tonight. And let's believe the fact that all these clauses in the 20th Amendment are really intended for development purposes. Question to you is, there needs to be accountability and transparency in a country, even when it comes to development. That's an important aspect. How practical is it for the government to move forward with their policies on development and bringing Sri Lanka into the future by abolishing the Audit Commission and the National Procurement Commission without establishing viable alternatives during this interim period until we get a new constitution?
Yeah, so I mean, I think when it comes to the National Procurement Commission, I think that is less clear because I think the National Procurement Commission and the way in which it's had to implement its mandate has also had great difficulties. So I mean, it's not to say that there's going to be a huge challenge with the National Procurement Commission. That said, I think it's important that an entity needs to be strengthened as opposed to abolished. This idea of creating entities, then abolishing them soon afterwards, things like that. I think things need to be built upon as opposed to just being sort of completely closed in. So I mean, even with the National Audit Commission, the National Audit Act, I think is actually a very strong accountability tool where, surcharge powers, finding the ability to find individuals directly responsible and surcharging them for the losses caused, those are very, very strong powers. And so, I mean, you know, dismantling those things and how that feeds into an economic, driving an economic agenda, it doesn't it doesn't really make much logical sense, but I mean, you know, it's a concern. I think also, I think one of the big questions above all is that, you know, there are lots of people in Parliament who voted for the 18th Amendment, who voted for the 19th Amendment, who may vote for the 20th Amendment. I mean, you know, just providing the reasoning why, you know, they are willing to support one thing, then another thing, then another thing, and I mean, you know, these are big changes. I mean, you know, all I'm saying is it just requires an explanation. You know, I think the problem that I face is that no one's wanting to explain why they shift from one position to another and then back to another. You know, I mean, because, you know, you know, lots of the same people have supported all three of these things. So
thanks, Asu. Thank you very much. I need to wrap up. So a quick question to Sudarshan before I leave the second round to play and then move on to the final round. What is the Supreme Court going to decide subsequent to tomorrow? Is it going to look at the legality of the amendments and the 20th Amendment draft bill? Or is it going to look at the social, economical, the ethical background surrounding the 20th Amendment to the Constitution?
That's a very important question, actually, because we hear that, you know, even though this is just a gazette, so, you know, this can be addressed in the Supreme Court. But Supreme Court has a very limited role. Supreme Court, when this bill was gazetted and had the first reading in the Parliament, there's a window for a week for citizens to make an application. Then Supreme Court is going to determine, in the determination, after hearing all these applications and intervening petitions, Supreme Court is not going to look at any other issue. Supreme Court will go and will only look at the constitutionality, whether this new amendment is inconsistent with the constitutional provisions. But since this is an amendment to amend the certain parts of the constitution, obviously that is possible by 2/3 majority. But there are certain clauses or articles we call entrenched articles in the constitution. These entrenched articles, or anything that affects the entrenched articles, need not just the 2/3 majority in Parliament, but also it has to be passed by a referendum. So Supreme Court is only going to determine whether you need the 2/3 only, or you need 2/3 plus a referendum for certain amendments. And now government is saying, anyway we are going for the referendum. So Supreme Court actually has a very limited role, because now what we see is that Supreme Court can say, okay, certain portions can get passed with 2/3, but certain sections you need.
But you can't ask complex questions in a referendum, can you, Sudarshan?
No, then we have to list number of questions. Like this present ballot paper, we have to list. Okay, do you agree this? Do you agree this? So I don't know how this is going
how
to
practical
it is. Yeah, but to answer your question, the Supreme Court has a very legalistic and constitutional room here, because it is the will of the government who claim that they represent the will of the people, and they can do whatever they want.
Right. So thank you very much, gentlemen, for your thoughts on the first and the second round. We are now moving towards the final round, so each speaker will get 4 minutes each to articulate your final position, but do not bring in new arguments, because if that's the case, we'll be going beyond our stipulated time frame. So do not bring in new arguments, only rebuttal is allowed in the final round. We start off the final round with Asoko Besekara, Executive Director of Transparency International Sri Lanka. Your final remarks.
Sure. Well, I mean, I think when we, it's going to be an interesting few weeks ahead. And I think this is just about ensuring that our accountability system, we can't forget about it. We can't say that we dismantle an accountability system to help us move forward. If there is an issue within any particular entity, it's a case of trying to identify what that issue is and strengthening it. Removing the constitutional recognition of a bribery commission and removing their power to proactively act, I think is fundamentally concerning. It's about, it actually comes down to this issue around fairness in our own society, you know. So I think that's a fundamental area. Looking at public finance, the government controls these things in trust for the public. If the government controls these things in trust for the public, why do we want to remove the accountability mechanism to the representatives of the public in Parliament? These are just sort of, you know, these are some of the ABCs of in these areas. These are not very difficult concepts or things for someone to get their head around. So I mean, I think it's just important that if that needs to be done, it should be articulated very clearly why you don't need a National Audit Commission, you know, just as opposed to just sort of dismantling it. It really needs, each of these individual areas needs to be actually addressed separately, and there needs to be, should have been a public discussion around these areas, as opposed to just saying, well, we'll just get rid of all of those things and we'll figure things out for the future, you know, with a new constitution that may happen sometimes in the future. So I mean, I think it's just a case of, there just needs to be some clarity around those areas, and people should then have an opportunity of sort of understanding what the consequences of those moves are. At the moment, it isn't there. I think the free and fair elections is a particularly a big consideration. Removing the power of the Elections Commission to issue guidelines on the public service during election time, I mean, I think that just resonates with every single person, that an Elections Commission should be given the opportunity of, you know, I mean, and I think the Elections Commission, much to their credit, has been able to administer a change of government in 2015 and then another change of government in 2019. So I mean, you know, if the proof of the pudding lies in the eating, the Elections Commission has shown that it has administered changes of government.
Thanks, Sukha. Thank you very much for your final thoughts. We now move our attention towards Attorney at Law Sudarshan Gulwardhana.
Yes. Now this whole debate of 20th Amendment is here, but still we have to consider 2 points. One is that this present government won 2 consecutive elections, or 3 maybe. So they have the president elected with a majority, and then the almost same number of people have voted for that party in the parliamentary election. So no one can argue that they have spent it. And they have put forward a draft, and that draft is now being discussed. We hope that this draft will change for better, but we don't know. We have no control over that. We have little control over it. We can only discuss the pluses and minuses. My point is that within 4.5 years, the government or the forces who were defeated in 2015 managed to regroup and get elected peacefully. The peaceful transfer of power, as Ashoka said, administered by the Election Commission twice. That was possible because the 2015 government actually democratized. They could have used the 18th Amendment. They could have continued with the 18th Amendment. Then opposition would not have much say. All these arguments would not occur, because then the president could have appointed judges to the commissions and everything. But that government, to its credit, tried to change and made a change. There may be issues, so we could have further developed. But during these 4.5 years or 5 years, opposition MPs, civil society groups, various groups linked to the opposition, one could say they are independent, but now they are with the government. So in the same way, the previous civil society was accused of being biased to one group, but various civil society groups came up during the previous government, used this opportunity. They used the free media space, they used the opportunity to go to courts and challenge the government bills and acts, and so then they managed to create the public opinion. Now, with all this support, they selected a common candidate again, President Gotabaya Rajapaksa. President Gotabaya Rajapaksa was not there when these people started building up as opposition groups, and then they agreed on one candidate and he was elected. But still, these groups, some are represented in the parliament and some are in civil society, they have a certain amount of power. Now what they are going to do with this is, you are transferring all this power to one person, one institution. They may have the trust in the present president, I have no doubt about that, that's no problem, but you are creating an institution, and that institution will control everything, and that will close the democratic space not only for us but also for them. So that's something that Sri Lankan citizens as a whole and also the various intelligentsia in this country, academics, professionals, need to think very thoroughly.
Thank you very much, Attorney at Law Sudarshan Gulwardena. Attorney at Law Lihini Fernando.
No, it's my opinion that this 20th amendment is quite detrimental to the country and to the democracy of this country. I think we've achieved significant progress by the 19th amendment, and if there are errors in the 19th amendment, the role of the government should be to correct those flaws and go forward and not lead the country towards disrupting this democratic framework, I would say. I think the 6.9 million voted for this government, but there is another 5.5 million who are democratic loving. So the president also said that he is the president of all, and so he has the right to consider the opinion of the democratic loving people as well. So I think countries have gone forward achieving development via democracy. How can one be a leader in a democratic framework? How can you generate sustainability, accountability, a transparent governance system? The role of the government, what I say is, should be to develop the system, not to break or cripple the existing system. So right now, from this 20th amendment, what we see is that it's bringing enormous power concentrated around one particular leader, and the parliament, where the mandate of the people is vested, is crippled to a larger extent. So, and also going forward, I think Sri Lanka is facing severe economic challenges in the years to come. Like by 2023, our debt levels will be around 10 billion or so going forward. Right now also there's about 6 billion odd debt that we have to pay. So the government needs to come up with a significant how to handle this economic crisis and the post-COVID, which we don't see. And they've been in power for 10 months. What is the significant achievement that they have done for the past 10 months? Even the loans that was given by the Japanese government to all these light rails, which was given at 0.1% interest for 40 years, was also withdrawn. So the general public must need to consider all these factors. What is the objective behind bringing this 20th amendment? And also going forward, I'd like to make an appeal to the general public. We all must be political savvy citizens. It is not the role of the parliamentarians or just people like us to come and question this 20th amendment. And a role of a citizen in this country does not and should not end just with the vote. But we all must be politically savvy citizens to question the role and the decisions of the government. So I think the general public, I'd like to make an appeal to read on this 20th amendment and to see whether this government and this president is doing justice by your vote. If not, to stand with the opposition to oppose the 20th amendment.
Thank you very much, Attorney Adlolihini Fernando. Professor Pratibha Mahana, Senior Lecturer, Faculty of Law, University of Colombo.
12 minutes, 4 minutes. Right. Now, I will start with this. Now there was a criticism earlier, this Sri Lanka COVID in number 2, and the source was not given. I like to appeal general public, just go to the WHO website. World Health Organization website, the chief of WHO has recommended how Sri Lanka basically controlling COVID-19 virus. So if there is any doubt, don't believe whatever we are second, but WHO has given who.org. So I am giving the source also, www.who.org, and click the statements given by the chief of the WHO. So there you can understand. So then I am now unbiased, right? Okay. Number 2, the main argument throughout this debate came up, this is an autocratic system. We are demolishing the democracy. So my argument is basically, this is only a draft. I also have my reservation. I am openly telling it. But I mean, for a time period, we must give the president to run the country without any restriction. That was the people hope. And people believed president. And then they voted in the general election also. What the people said, we really, president policies, president asked for a mandate to run my policies, he need a parliament with support. And if you go with the parliament with the earlier system, he could fail. So people trusted, people believe it. But I have my full confidence, and he is the person who saved the nation, and likewise he will save this country. But it can be certainly with this amendment only for a particular time period. And then you go for the new constitution, right? Now my argument is this: if you don't like the executive president, scrap it. Or if you want this system, so no need like asking 25 questions. Only ask one question: whether you need this executive president or not. If people say executive president needed, then criticism may come up. So my argument, the other one, all these independent commissions, how they functioned last time, even to whom they were biased. The speaker, the former speaker, never done anything in the Constitution Council. Even he could have brought all these members and give advice. No, he is giving recommendations. So bias. Former speaker was biased, covering to the independency framework, democracy framework. They never question. So how can you run a system like this? That's why the 19th Amendment failed. Once the 19th Amendment failed, rather than putting patch up for the 19th Amendment, my argument to a interim period, you need the president to run the country or even develop the country. I have my trust. Like Singapore took 6 months. Even Cuba took 2 years. This country within 6 months, the president can develop and run the system to a very viable position. I know how many migrant workers are coming to Sri Lanka now. 32,000 had come always. Another 55,000 ready to come. So all these people to run the economy, we need a system. That's why we are trying to finding it. There can be certain things. I am not going to discuss the 30-year age and certain things. I don't know. Even just check the France Prime Minister, what was his age he came. So there are plus and minus points. So I appeal general public, one thing, until we come up with a constitution, we have to empower the president. Efficient government is needed for this country. That can be done only through discipline. That's why these road rules, lot of things are introducing, not to undermine the democracy, not to undermine anything, to run a country where Sri Lanka can come to a top stand. For that we need the visionary leadership and a very strong leadership we need. I think the parliament may support whatever the amendment put forward after the Supreme Court determination, and also given room to discuss in the parliament committee stages. And while happening that, I appeal general public to submit your recommendation for a new government. I have seen in India 1.7 million submitted their recommendation. So lot of ideas, lot of good things are there. While it worked, basically this system, if people thought abolish, 2 power centers cannot run the country. Not I am telling, my good friends leader, former president, always he said because of these loopholes, because he has that practical experience. But now I am not going to further elaborate it, but my final argument is basically come up with a new constitution which empower democracy and other good principles. Thank you very much for giving me this opportunity. Thank you very much.
So you took 8 minutes, Professor Pratibha Mahalanamaheva, against the 9 minutes that the other three individuals took. So equally, almost there.
So Sir democratically gave me the time. Thank you.
So
very much. So I finally appreciate it.
Thank you very much, Attorney at Law Sudarshana Gunawardhan, Attorney at Law Lihini Fernando, Professor Pratibha Mahalanamaheva, as well as Ashoka Besekar for joining us this evening on the show. Thank you very much, John, Shalan, as well as Nadim. It's always a pleasure to have the three of you on the show. I leave you tonight with a quote, as I always do. In questions of power, let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. Take care. And good night.